opposed to a will to do their planning, so they're not subject to the statutory fees. And in very large estates, the statutory fees can be very significant. You asked a question as to additional fees besides this minimum statutory fee, and California law does provide a fee for additional services. These are called fees for extraordinary services, and they're discretionary with the court. The court can take into consideration a number of factors, including the size of the estate, the type of services that the court typically considers to be extraordinary would be the sale of a business or real estate, any sort of litigation involved with the decedent's estate, creditor claim litigation, will contest litigation, things that are not ordinary in the general course of an administration.
Okay, good. So another question that some people may not know about is what happens if the decedent died without a will?
If the decedent dies without a will, you actually have a will. It's called California's default will.
Okay.
And what that means is California has a scheme as to who will take your property in the event of your death and in the absence of any will, trust, or beneficiary designation on types of assets that are allowed to pass that way. As an example, under California's default provision, if you're married, your spouse will receive your community property. If you're married with children, community property will still go to the spouse, but separate property will go to spouse and children, depending upon how many children there are. And then there's a whole list of, quote, legal heirs that will be entitled if there's no spouse, there's no children, there's no grandchildren. We look at what's called a table of consanguinity for purposes of determining who are your legal heirs and who's going to take that property. And there are quite a few good court cases reported out there as to the battles as to who might be the intestate heirs. I think the point being, don't leave it up to the state to determine who should receive your property. All of us have ample time to complete a very simple will indicating what our intentions are and doing it correctly.
Right, and unfortunately, too many people don't get around to it.
Well, we're not immortal. Some people think they are, but we're not.
Okay, I was surprised recently. My father passed away, and we found that actually we needed to have some cash available, including, a lot of people aren't aware of this, that the last month, the Social Security paid for the month of death has to be repaid. The pension payment received from the retirement plan for the month of death has to also be settled in some way, and so forth. So do you have any thoughts about cash, having some cash on hand in the event of death?
You know, that's a more difficult question since we don't know when we're going to die, at least for the most part. Most of us don't. Having cash on hand is helpful. By cash, you mean money in the bank. In a probate administration, if there is an urgent or crisis situation, the laws provide that we can get into court relatively quickly and get letters of special administration or get someone appointed to handle a decedent's business or to foreclose a mortgage from going into default or things of that nature. But those are exigent circumstances, kind of an emergency. The repayment of the Social Security benefit, the repayment of the pension benefit, yes, they have to be paid. What I tell my clients is if you can afford it, go ahead and repay it and we'll reimburse you out of estate assets in most cases, once I have a good picture of the situation. But if you can't afford it, you know, once you're appointed and once you have control as the executor or administrator of an estate, you're going to have access to the decedent's assets. Most creditors that I've ever worked with certainly understand that it's going to take us a month, maybe 2 months to get into court, get someone appointed before they're going to be reimbursed.
Okay. Yeah, I've seen the situation, you know, these little old ladies get together in many cases, we say little A's, it could happen to the guy at the barber shop too, I guess. And they share these stories, and then the next thing you know, they're running down trying to administer the estates themselves, sure, pulling the cash out of the bank as fast as they can. Okay, the next question is, what is an executor and what is an administrator?
These are formal words. An executor is the person nominated in the will to be the, we use the generic word, personal representative. If you draft a will, you name someone to be in charge of your estate. That person, if they're appointed by the court under the will, is called an executor. An administrator is the person, generally if there's no will, the person again appointed as the personal representative to be in charge of the estate of a decedent. There's a third category, and that's administrator with will annexed. And this is a situation where the decedent had a will but didn't nominate anyone to serve as executor. So the will is still admitted to probate to be proved as the last will, and the person is called an administrator with the will annexed. All three of those terms, executor, administrator, administrator with will annexed, are the same term. They're still a fiduciary, meaning they have legal responsibility and rights and duties and obligations to the beneficiaries and heirs under the estate. They serve the same role as to inventorying the assets, paying the decedent's creditors, and ultimately distributing the estate under court supervision.
Okay. Let's see here. Okay, here's a good one. If you're nominated as the executor, are you required to accept? And then what should you think about before you do accept?
Sure. The answer is no. No one's ever going to put a gun to your head and say you have to be the executor. Frequently, the executor that's been named or nominated in the will might be infirm, might be elderly, might not have the time. So there's no obligation for you to say yes. And in fact, when we counsel clients, one of the things that we talk about is the job of being an executor or an administrator. This is not an easy task, and yes, you will be compensated the same as an attorney's compensated under the statutory scheme for probate estates, but it is a very time-consuming task. You know, what should you think about? Number one, do I have the time, and can I make it available for purposes of making sure that I administer this estate properly? So in sum, you do not have to accept, but if you do accept, you're going to be charged with a fair amount of duties. You can be found liable if you don't perform those duties according to the law.
Yeah. So we were talking again a little bit about this before, and a lot of people may be kind of scared about this, and with some reason, you know, they should be conscientious. We want them to be conscientious. But we also want them to be aware that there is help available. So, you know, you have an attorney, you have a CPA there to sort of hold your hand and lead you along the way.
What we try and do is make the job pretty easy for our clients. Not only giving them kind of a to-do list each and every month. This month we want you to get these tasks performed. And if you have questions, call us. But we pretty much lead them from one task to another to make sure that they're carrying out their job responsibly.
Right.